So nice crowd. I sent an email to all the folks who are participating today last night, and I said, hey, it might just be, us talking to each other. I was wrong about that because we're up to about 137 participants. So that's really wonderful. So for those of you who don't know me, I'm Kim Mutcherson. I'm the co-dean of Rutgers Law School on the Camden campus. So if you're calling in from somewhere that is outside of New Jersey, you don't know Jersey geography, I'm a Philly person, not a New York person. And we're going to have a conversation today about building an anti-racist law school. I want to start first by in order to make this happen. So pretty impressive that we were able to pull this off in such a short amount of time. And I'll just ask again, everybody, please make sure you're on mute.
Yeah, because he's...
Team Mutcherson, you're muted.
Sorry. I'm a Zoom person. So what we're going to try to do here is have a pretty informal, facilitated conversation for the first 40 minutes or so on the topic of creating an building an anti-racist law school, and then we're going to open it up to the crowd for Q&A. So where I want to get started, actually, this is what I was going to say before. I also want to just thank all the other deans who helped make this happen, and particularly the folks at Cincinnati, where Verna Williams is the dean there, for making WebEx available for us to do this today. So thanks very much for that. So I'm going to ask everybody from Rutgers who is participating in this conversation to just introduce themselves, briefly name how long you've been at the law school, maybe a little bit about what you teach or write about. And I'm going to start with David Lopez, who is my co-dean.
Hi, thank you, Dean Mutcherson. A big shout out to my old friend Dean Williams at University of Cincinnati. Thank you for organizing this. I have been co-dean at the Rutgers Newark campus going into my third year. My background is in civil rights. I put together a class last year on the law and social justice movements. The whole goal was to take the students to Alabama, Mississippi, and Tennessee to study the history of the civil rights movement and grassroots movements in all those areas that got canceled by the pandemic. I also teach classes on algorithms and civil rights. So very happy to be here with you today.
Thank you, Dean Lopez. Katie Iyer, can you introduce yourself?
Thank you. And thank you so much to Dean Mutterson and to the rest of the organizers of this day of events. I think it's a really exciting sort of programming, and really happy to have our students engaging with these ideas. So my name is Katie Eyer. I've been at the law school since 2012. I teach civil procedure, constitutional law, and a variety of other anti-discrimination law classes. And my scholarship is also based in anti-discrimination law, and that is my history as a lawyer as well.
Thank you, ma'am. Elise, Boddie? Elise had emailed me to say that she was having Wi-Fi problems, so it's possible she didn't make it on yet. But... Okay, let's get to the next person then. Adnan, Zulfiqar, introduce yourself, please.
Okay, I am, can you hear me? Yes, all right. I'm Adnan Zulfiqar. I am the youngest member of the crowd, or at least from the standpoint of the newest relative faculty member. I teach criminal law, criminal procedure, investigation, so everything up to trial. And I teach Islamic law, and I will be teaching a course in the spring on police prisons and protests. My areas of interest, scholarly interests, are around sort of some of these issues. So policing, protest, revolution, and then broadly Islamic legal history.
Awesome. Thank you. Norrinda?
Sorry, I'm trying to unmute. Hi, everyone. Can you hear me now? I'm sorry. Thank you to the deans for putting this programming together. I'm Norrinda Hyatt. I am in the Newark campus of the law school. I direct the civil justice clinic here. I also teach courses on housing law and importantly today, and I think always, critical race theory. My history as a lawyer was in the Civil Rights Division of the Justice Department, and I did housing discrimination, civil rights work there, and looked at the intersections of policing and housing. I continue to think about those issues in my scholarship and do a lot of writing on the policing of voucher holders and public housing residents. So I'm happy to be here.
And once again, if you're not speaking, please make sure you're muted. And then last person on our, last but not least, Adil, can you introduce yourself, please?
Hi, everyone. I'm Adil Haque. I teach criminal law and I teach criminal adjudication. So I take the baton from Adnan and I cover, we call it bail to jail. So bail, preventive detention, right to counsel, right to jury, sentencing, appeals, habeas corpus, all of that. And then I also teach the law of war and jurisprudence, and I primarily write on international law and the law of war and peace, kind of broadly construed.
Great, thank you. So let's get into the fun part of this. So one of the things that I think that I want to start off with here is the term anti-racist, I think, is not a term that everybody has been using for a very long time, although we've all been using it for the last 4 months or so. So what I wanted to start off with is actually just sort of thinking about that term and how we've been using that term and how is it different to be somebody who's anti-racist as opposed to being somebody who says, oh, I'm not racist, right? Why are those not the same thing? Katie, can you start us off? Sorry, Professor Iyer. I'll try to do that.
Yeah, I'd be happy to. I have to say, for me, as a white ally of racial justice, the distinction between being an anti-racist and saying I'm not racist is really a very significant one. So if you're a white person in this country, right, and you're thinking to yourself, I'm not racist, you're almost certainly wrong, right? Racism is the stew into which we're born in this country. And the very first step, I think, to being a proactive advocate on behalf of racial justice is being able to recognize that within yourself and reckon with it. Being an anti-racist offers you the opportunity to hold that truth while at the same time committing yourself to doing the work of racial justice. And I think that's really important, to be able to recognize that being active on behalf of racial justice doesn't mean denying racism. Racism means reckoning with it both within yourself and within broader society.
Great. Adil, do you want to add anything to that?
Yeah, so I guess I'll just say that from my perspective, in a way, anti-racist is easier to understand than non-racist. So anti-racism is about actively identifying and confronting racist structures, practices, habits of mind, habits of behavior. So it's an active posture of opposition. Non-racism, in a way, is harder to characterize because you can't just think of it as passivity in the face of racism, as if you can take yourself out of it and sort of be an observer to it. Because part of the point, I think, of the concept of anti-racism is that if you're not actively fighting racism, you are inevitably in some way, shape, or form contributing to it. So there is no neutral stance. There's no way to take yourself outside of it and just say, I'm not contributing to it, but I'm also not fighting it. I have my own concerns. But that doesn't really exist. And I should also emphasize that that's not just true for white people. So as a person of color who is not African American, there are a variety of ways in which I contribute to systems of racial hierarchy, whether it's in the education system or housing or whatever. And so for me too, there is no neutral position, right? I can't just say, look, as a American Muslim, I have my own problems. I'm going to focus on those. No, I have to join the fight because the alternative is not leaving them in place, but actually contributing to some of those problems.
And Norrinda, I know that you wanted to jump in here as well.
Yeah, I just wanted to make two quick points, which is that the legacy of the use of the term anti-racism is a direct line from Du Bois. Manning Marable was using anti-racism. So I think we've tended to reflect on this term as new, and it's like, it's trending, but it's been trending recently, but a long time coming, because it's deeply rooted in the fight for racial justice in this country. And also, just to pick up on Adil's point, which is that even as a Black American, you can be, I was in conversation with Ibram Kendi last fall about his book, How to Be an Anti-Racist, and his chapters really point to how Black people in America also need to do active work to be anti-racist. So to Katie's earlier point, this is work that we all have to engage in.
Excellent. Thank you. I'm actually individually going through and privately chatting people to tell them to mute themselves because I can't handle it. So please make sure that you've muted yourself if you're on the call now. So I think that was a really helpful sort of foundation for people to think about the conversation that we're trying to have here today. So my second question that I wanted to pose to folks was, presumably every American institution should strive to be anti-racist in the way that we've just been talking about that. But do you think that law schools have a particular responsibility to be anti-racist? And if so, why do you think that? David, do you want to start us off with this one? You got to unmute yourself, David.
Thank you. When I think of anti-racism, I think of affirmative obligations to engage with the history and the contemporary reality of structural racism. And I use the analogy of the mask, which is very contemporary. Wearing a mask is an affirmative obligation to others. Not wearing a mask may look neutral, but in fact, it sort of functions in an aggressively hostile manner. So when I think about this institutionally, as I think the inability to really to be neutral in addressing both the contemporary reality and the history of racism, I look at the central importance of law schools in terms of validating, I think, belief systems in our country, right? And you look at, historically, the way that the Supreme Court really stepped in and ushered in and legitimized the whole Jim Crow era through a series of decisions. So I think the law has a particular legitimizing structure that really needs to be unpacked. And this has consequences for every single aspect of society. So in that sense, I think it's really important for, us to look critically about how the law has been used to legitimize racial and other forms of subordination. And that really kind of places us, I think, at a really critical institutional educational point to address these issues.
Thank you. Adnan, do you want to answer that as well?
Sure. I think the question of law schools having a particular responsibility, just picking up on what David said, I think the law itself, for a number of reasons, is crucial for the type of society we want to build. I think that a society's values get encapsulated within the law. What it considers to be moral, immoral gets captured in the law. And so as a result, our relationship with racism itself and what type of society we want to be is shaped in many respects by our relationship with the law. And in that respect, it can be problematic where it's legitimizing, but then our history also, sort of, at least in this country, and I would say elsewhere, shows us that this is also the platform in which people manifest or express the way in which they're going to be anti-racist, by challenging legal structures through the law. So I think that law schools have a responsibility to equip students with the ability to do that. And I think, and this is a point that I'm going to harp on a bit, I think history and legal history, which in many respects is oftentimes very absent from law schools, is absolutely crucial to this. We teach the law as though it occurs within a vacuum, whereas anyone who teaches, for instance, criminal procedure knows, hey, there's a whole history at which we've come to now this particular set of laws, some of them good, some of them bad, and the students need to know that. So that, I think, is a major responsibility for law schools.
Got it. So actually, since he raised history, I'm going to go back to you, Katie Iyer, who is a legal historian, along with the other work that you do. Let's talk about what are the markers of an anti-racist law school, right? If you want to market yourself and you want to claim to be an institution that is anti-racist, what does that look like?
So this is one of the questions that when you sent it last night, I spent a lot of time thinking about, because I think the answer can't be that you've achieved certain goals, because the reality is that this is an ongoing project, just as the project of deconstructing racism in society is a long and ongoing project. And I don't know that we'll ever reach a complete stopping point. So to me, what really is the marker of an anti-racist law school is the consistent central commitment from the institution, from the top down, to doing this work, making it central and not peripheral, not being afraid to speak loudly about it to our communities, and to really engage all stakeholders within our communities around it. Some of the specific things that I know we are working on as an institution, and that I see as key to any institution that aspires to be anti-racist doing, right? Educating our the people within our institution, not just our students, our faculty, our staff. I don't know.
Hi, can I put an order for pickup? Can I get a James roll and a crab rangoon?
So your lunch sounds fantastic.
That's it.
But we don't all want to hear about it.
Okay, great. Thank you.
Oh my gosh. So I think part of the problem is that a lot of the call-in users have not muted themselves. So if you have called in, the problem is when you mute people, and I'm not the host, just so you know, when you mute people, that everybody gets muted, which is fine, but then it often cuts off the speaker as well. So Shannon, could we do this? Could we just mute everybody right now, and then we'll unmute. We'll have to probably do that periodically.
Yeah, that's the reason I haven't been doing that, is because it does mute the speaker. But I can do that if the speakers just want to know that when they're speaking, they'll have to unmute themselves. So I can just periodically start muting all. We did have a question that was if this recording was going to be available for everyone. So I don't know if you wanted to address that as well, but I'll go ahead and mute everyone.
Yeah, that's great. Thank you.
Sure.
Yes, the goal is to record these sessions and then to make them available to folks afterwards. So keep that in mind if you're planning to say something that's totally off the chain later. All right, so
actually go ahead, everyone. I'm usually down.
Thank you. So
everyone's been muted, so now the speaker needs to unmute themselves.
I just did. Thank you. So just to finish the specifics, taking this commitment and looking at educating the people within our community on issues of race, students, faculty, staff, commitment to racial diversity at all levels and in all pieces of our law school, doing what we can to address the larger structures of racial inequality that our students face both upon entry into law school and upon exit into the profession, thinking about things like the bar exam and the structural obstacles it poses to a variety of communities to access to legal practice. And then finally, supporting the important work of both our faculty and our students around racial justice, because there are, within any given law school, many sites of important work around these issues.
Great, thank you. Elise, I saw that you were on, so I wanted to just give you a chance to introduce yourself, or just say sort of our names and how long we've been here and the work that we do. And then if you want to jump in on the question too, that'd be great. So the question was, what are the markers of an anti-racist law school?
Sure. So I'm sorry I was late. I was having technical issues. Technology fairy is not looking kindly on me today. So my name is Elise Boddie. I teach constitutional law, both an introductory course and an upper level course. I teach civil rights and state and local government law. I think I'm in my 8th year at Rutgers, although years are starting to run together a bit. What are the markers of an anti-racist law school? So I guess I think that both in terms of outcomes and as well as process. I mean, I think for as a process concern, I think an anti-racist law school is one that engages students, in particular students from different racial backgrounds, historically marginalized groups, and engages them in a process of sort of hearing from them about the experiences that they're having in law school, taking active steps on the part of the faculty and the administration to address those issues, and essentially to give Black and brown people and other racial minoritized groups agency over the experiences that they're having in law school, because I, for one, don't profess to know everything that is happening at the student level and how they're experiencing the law school. So I take including their voices to be critically important. In terms of outcomes, I guess to create a safe space for students. And by safe, I don't mean sort of safe from inquiry and safe from sort of exploration of difficult ideas, but to create a context in which students feel free to express themselves and safe in expressing themselves and their reactions to things that are happening in class, the struggles that they're having both in and outside of class in ways that are, free of judgment. And I think I'll leave it there for now. Other ideas may occur to me as the conversation goes on, but I'll start with that.
Thank you. David, do you want to add anything to this part of the conversation?
Well, let me sort of pick up where Katie was. I think an anti-racist law school is one that never announces finally that it's anti-racist, that it's always an ongoing engagement in the project of anti-racism. And to really kind of springboard on what Professor Boddie was talking about, the way I look at it is that there's a real subjective element in both the faculty, the student, and the staff community in terms of whether their voices are central to the community. I went to a diverse law school. Many of us went to diverse law schools, but we felt as though we were the parsley on the plate, never the entree. That's the kind of the way I want to put it. I think it's really important for all voices to feel like they're a central part of the community. And really, as the dean, that's really my arbiter, my metric to really strive to make sure that every voice, including students of color, including students who are first gen, especially in many ways, feel like their voices are a central part of the dialogue in the community about issues of justice and the rule of law. And in order to do that, that means that the law school needs to meet the students where they are, right? And really involve all students as central players in the community. And I think to the extent we have students who, feel marginalized in the community, particularly along, lines of race or gender or sexual orientation, then we really haven't achieved our goals in terms of building a real community where every voice is critically important to the discussions that are going on.
Okay. So, we have a lot of stuff that folks just put on the table about, what we should be thinking about in terms of being an anti-racist law school and what that would look like. So here's the hard question. What are the obstacles, right? Why isn't every law school an anti-racist law school at the point? What are the things that make it difficult? What are the things that make it feel impossible sometimes? What are the barriers that folks have to break through in order to rebuild our law schools? And I say that because one of the other things that I think is important to put on the table here is that law schools are deeply conservative institutions, and I'm not talking about politics, right? I'm talking about the pace at which law schools grow and adapt and change is glacial sometimes. So if what we're talking about here and what I think a lot of students want, right, is this sort of snap your fingers, let's change the institution, what makes that process hard? What makes it difficult? Let's see, who should I start with on this one? So Adnan, you've been at you're the youngest, as you like to say. So, you've been at Rutgers only for a short time, but obviously have had experience at other institutions. So let's have this conversation. What is it that makes it hard to be the kind of institution that we say we want to be?
Right. So I think there's two main things that I'll comment on with this. I think there's one consideration that we have to make, which is that we are a law school that exists in the United States of America. And part of the challenge that the law school also faces in terms of shifting is that we are very, very, very behind on the conversation of race within this country. And part of that is because of sensitivities that we have just to the topic, that as soon as the topic is raised, there is a whole segment within society, I would argue on many sides, that becomes very reserved. I noticed this in particular when I sort of traveled and spent my 1L summer in South Africa, where I felt as though the conversations around race were a lot more honest, were a lot more sort of out there, and people were having them, and they were in diametrically opposed conversations, but they weren't sort of hush-hush and people weren't afraid of this. And so I don't think that we as a society have developed a way in which to talk about race constructively. So that is a major challenge that I think travels into law school. I think within law schools itself, part of the challenge is that when we, as you noted, in terms of being conservative and sort of having difficulty in changing, when we look at our curriculums, and I don't think we do enough introspection. And I think one of the challenges, and this goes to the question of being an anti-racist law school, I think an anti-racist law school has to be in a consistent posture of introspection with regard to where they can make changes to help with folks who are on the margins, or conversations that are on the margins, or theories that are on the margins. How can we make those types of institutional changes so that, going back to this point that Elise brought up, it's not a matter of sort of cutting off other areas of speech. It's really a matter of building out and filling in the gaps in speech that we have within law schools currently.
Thank you. And Molly, let's see. Norrinda, do you want to jump in on this one? What are, again, somebody who's newer to the law school, but what are some of the things that you've identified already?
Right. Yeah. I would say that I have 2 points here as well. One is whether law school is the dog or the tail, right? And I think we are very focused, and as we should be, on getting our students employed in employment, and where do we send anti-racist lawyers, right? So even if we train them, where do we, there's only so many honors hires at the Justice Department, and then there's only so many spaces to go in other places outside of the government. And so I think in terms of making sure that our students are employed and employable, we tend to provide coursework that perpetuates the system that we see there being opportunity for them in. You know, I think we have to start thinking about other systems, but it's like, do those systems change before we change, or do we start training anti-racist lawyers and have them go out and create these systems? And I think that's something that we are going to start wrestling with, right? I also think that when you talk about students who are POC, first generation students who feel some level of obligation, this is deeply tied to employability and how much money you will make. How much does one get paid as an anti-racist lawyer? I don't know. We're still in the process of figuring that out. But I think we hear from students a deep commitment to being able to help others. They're in, mixed class families where there's a deep obligation sometimes to reach back and to help. And you may not be able to do that in some of the spaces where we see anti-racist work cropping up. So I think it's both attention for us and for some of our students who might be inclined to do this work.
So I like that. It dovetails with another question that I wanted to ask. And then I'll give you forewarning, Adil, that I'm going to come back to you with the academic freedom question. So be prepared for a fire answer to that question. So what I wanted to say in response to what you just said, Norrinda, is, I think one of the things that we, as you said, we're preparing students for a particular career in a profession that's a pretty conservative profession as well. And what are the opportunities for people to do anti-racist work? But I also wonder, all of our students aren't going to end up doing that work, not just because there aren't jobs for all of them to do that work, and not just because of the financial impediments. Not everybody wants to do that work, right? Not everybody wants to be a social justice lawyer. And so part of what I have found really challenging is being able to talk to students about what are the opportunities to do good work, to do social justice work, to do work that is anti-racist in environments that themselves aren't particularly conducive to that work. Right. What are the ways that you can even change your work environment so that it feels like a better place for people to be? So I wonder if, Elise, can I ask you to jump in on that question? Right. I mean, what about our students who aren't going to be in the world they're not going to be public interest lawyers, they're not going to be social justice warriors? What work can we get them to do?
So I'm happy to talk about that. If I could I want to just challenge the premise a little bit about law schools being inherently conservative. I think law itself is inherently conservative, right? I mean, we teach about the importance of precedent, it's very decisive, we're bound by certain traditions and customs and the way that law is practiced when you walk into a courtroom. It's very formal, right? There's certain sorts of etiquettes that sort of grow up around the practice of law, etiquette that grows up around the practice of law. And so I think that law is inherently conservative in many ways, but I don't think that law schools necessarily have to be conservative in the sense of being resistant to change. You can have, at Rutgers Law School, especially in the newer campus, there is a tradition and history of, much more sort of radical. I don't know if radical is the right way, but I think the right term. But I think certainly in the earlier history of the law school, there were members of the faculty who were very forward-thinking and sort of thought pretty transformatively about how to approach, what a law school should look like and how it should operate. So I think it sort of depends on, who's in the building, but understanding that, as Norrinda was pointed out, there are certain things that we are bound by that can sort of limit or at least cabin the what we teach and perhaps how we teach it. Just for example, I teach constitutional law. I feel bound to, sort of teach my students the actual doctrine of constitutional law. But that being said, I think there are ways to challenge that doctrine as it's being taught. So there's that. With respect to sort of social justice and public interest work, I did civil rights litigation for a number of years with the NAACP Legal Defense Fund. There are other sort of social and public interest organizations. Those organizations, I don't want to say that those organizations are free from racism, right? They have their own sort of structures, especially, sort of the older ones, the older guard ones that, have their own challenges, for sure. I can tell you, I'm not speaking about LDF, but I do know about others that are wrestling with very significant challenges around this issue. But I think generally it's important for students to, to explore a variety of options and to pursue their passions, whatever those may be. And public interest certainly can be rewarding in ways that, for some people, including myself, the form environment was not, did not necessarily feel that way.
Professor, there is a comment here from Zachary, and it says maybe instead of training lawyers to be anti-racist, you could train anti-racists to be lawyers.
Happy to do it. We'll take them all. Let's see. So let's, I always write questions and think, those will go really quickly, and then they're taking a long time. So I want to make sure that we have time for Q&A. So I do want to go back to the question that I was going to pose to Adil, which is, as we're talking about this idea of transforming, the ways that people teach oftentimes and asking to change the curriculum, one of the pushbacks that we'll often get from other professors is, well, you can't impinge on my academic freedom, right? And trying to turn this into an anti-racist institution is interfering with my ability to be the, whatever I want to be in the institution. So, how do we respond to that?
Yeah, great. So I don't think that being an anti-racist institution has to impinge on the academic freedom of individual professors or individual students. And we should also maybe talk about that a little bit. Nevertheless, I'm glad that Dean Mutcherson flagged that this will be a significant framing for the pushback, because academic freedom is a widely accepted value and it sounds very neutral. So if you're going to oppose anti-racism and you can try to make use of academic freedom, at least rhetorically, it's very effective. So we should be aware that that is going to happen. And basically the way to, the reason why these two things are not in tension is that an institution can implement a strategic vision and commit itself to certain overall values and structure its general curriculum with certain goals in mind, while accepting that individual professors may take a different view. And this is true for any value, even one as abstract as the rule of law, right? As an institution, we're committed to the rule of law and professional ethics as lawyers, even if there is an individual professor who is an anarchist, right? Or who thinks that professional ethics is a myth, right? And we should just do what is morally right, irrespective of professional ethics, whatever. Individual professors can have their own perspectives, and to some extent that will come out in their teaching and in their syllabus and their curricular design. And that's understood, and that's not a left-right issue. There might be a Marxist professor who thinks race is a social construct and we should talk about class, fine, right? But as an institution and as a community, if we want to set certain objectives about what we want our overall education to look like, so that at the end of 3 years, every student graduates from Rutgers understanding the role of race in the construction of our legal system and its operation, then that is something we can pursue as an overall institutional goal, accepting that there will be some professors who don't want to reorient their own class in that way, and they are free, right, as academics not to do so. But that shouldn't stop us from setting that as an overall institutional goal.
Great. So I do want to be able to start letting people jump in on questions. I did want to follow up just a little bit on what you said, Adil, which is that tenure is a really powerful force in academia. And so, you know, when there are situations with professors who, you know, students may think, you know, this is not a person who should be in the classroom, or this is a person who doesn't understand, or all of those things can be true. And yet, right, our power to sort of shift that dynamic is very small. And so definitely there are ways in which we consistently want to be able to build the institution. And there are also, as we said before, there are obstacles to how we can move things. So I've got a question in the chat. That's a really great question. So I want to put this out to our panelists. I think maybe I'll ask, maybe Norrinda, I'll ask you to jump in on this one first. So how do we begin reform? This is a question from Ralph. How do we begin reform to the system when the entry and exit points into the school or profession are monuments to white supremacy? So the LSAT and the bar exam. Super easy question. Take it, Norrinda. Fix the problem.
You know, I think that is an issue that we are all tackling and thinking about. You see some schools are doing away with this, right? And that's one way to fix the problem, is looking at metrics beyond, or just not looking at the LSAT at all. I mean, we're also right now, due to COVID, thinking about the bar exam, right? New Jersey's student graduates in 2020 are seeking you know, to not need to take the bar. And, you know, these things are complicated. As I think about it, unless we're really going to undo the full system, doing away with parts of the system can be problematic. One thing I worried about is that students of color, young junior lawyers of color, without the badge of the bar, subject themselves to a questioning by the system that I worry could end up hurting them, right? Like, what we know about professions that have these metrics is that people of color do better, let's say, than in marketing or advertising, where you can't take these exams and show I know just as much as everyone else. So unless we do away with the whole thing writ large, I worry deeply about pockets of students, pockets of the profession not having this badge. And I particularly worry about people of color not having it until the whole thing is undone, because that is what propels people of color into the marketplace at equal footing with everyone else. So I just, these are, you know, I'm for taking the whole system down. I'm just not sure whether we get there, in what manner we're going to get there, and I worry about the damage to people of color, students of color, in the process. So, Ralph, good question. I have no answers, but that we move with caution. To do no harm.
Those are great points. Katie, do you want to jump in here?
Oh, sorry, Dean Mutcherson, you've got a couple people raised hands.
Oh, okay, great. So I'm gonna let Professor Iyer jump in on that last question, and then we're gonna call on the folks whose hands are raised.
So I think this is a great question. To me, this is part of the obligation of being an anti-racist law school, is looking not only at what happens to folks within our building and what's going on within our building, but what are the structures that exist, as you point out, at the front end and at the back end. Right. And there's, you know, drawing on the points that Professor Zulfiqar made earlier, right? There's history here. The bar exam in particular was adopted in any number of states, specifically for the purpose of keeping people of color out of the bar. And it continues to disproportionately do so, as does the LSAT. I think Professor Hyatt's point is also critically important, which is it can also serve as a sort of guarantor of equality for certain individuals. So it is important to think about that and recognize that in moving forward. But I do think an initial step, for example, would be the ABA no longer requiring law schools to use standardized test scores as a metric of admission. That perpetuates a system in which law schools are obligated to do this. And then they, you know, the US News turns around and uses it as the basis for their ranking. So it creates a position in which you can't even have experimentation within the legal law school market to decide, we don't think standardized tests are the best metric of who's going to be a good lawyer, so we're going to opt out of this and really look at other things like experience and grades and the like. So I think that's really important. On the flip side, I've been doing some work with others at Rutgers to think about bar exam alternatives. I think we're at a pretty unique moment in that, and this ties into one of the other questions that Dean Mutcherson may ask later, where the interests of lots and lots of law grads are aligning with a recognition that the bar exam is actually a pretty terrible metric of who's going to be a good lawyer. The reason this has come to their attention, right, is the fact that with COVID-19, we are experiencing all sorts of disruptions of the usual bar exam testing process and really awful conditions for grads who graduated in 2020. But that's called a lot more attention to the fact that the bar exam itself, right, it has never been validated for its predictive validity in terms of its people's ability to practice law, and that it excludes lots of folks who might be good lawyers, while including folks who may not possess the basic temperament to treat their clients appropriately.
Thank you.
Sorry, there's a question about if there's data that states without the bar requirement, like Wisconsin, are less competent or more likely to be sanctioned or sued for malpractice.
So I can respond very briefly to this. There's very limited data out there. There have been very limited attempts, even by the NCBE itself, to study the bar exams prediction of whether attorneys are good attorneys. The limited research that's out there mostly looks at what's tested on the bar match what lawyers do in practice, and those results have been fairly damning, right? What lawyers do in practice has a lot more to do often with practice skills than with memorizing the minutia of particular bodies of law.
All right, so I know the hands are up. Kiva. Uh-oh. You still here, Kiva?
Oh, yes. I didn't mean to have a hand up, Dean. I apologize.
Oh, no worries. Dr. Rahim.
Oh, is that me? Okay. All right. Thank you for having this, and shout out to Rutgers Law for doing this, really. I'm glad to be a student here. So we're all familiar with Charles Hamilton Houston's a lawyer is either a social engineer or a parasite. And so I'm curious, considering that the political fault lines of division are more conspicuous today, and capitalism and patriarchy, homophobia, all these things play a role, is it useful for law schools now to kind of teeter the fence, such as, for example, there may be students who aren't going to be committed to doing this work. However, they can change the space, knowing that there are such great divisions now to where it's almost very clear that you have to pick a side, whether you're going to be for social justice, protecting marginalized communities that are under assault, or you're going to be a part of systems, institutions, and law firms that are perpetuating that very injustice against communities.
Let's see. David, you want to jump in on that? You got to unmute yourself.
We've discussed this issue a lot. And, I would start out by, I remember something that my law school dean once said when I went back as an alumni. It's like, why do we call schools law schools instead of justice schools? Why isn't justice at the centerpiece of what we're doing in the law school? And then you sort of use that as a first principle and you take it from there. I think that your question is a very important and urgent question at this time. I know that you've heard me talk about, I know the other people on the call haven't heard me talk about something that I should not talk about on a call with 249 people because it involves a conspiracy, right? This is the sort of L. Slocum idea. L. Slocum was one of the godfathers of Rutgers minority student program 50 years ago. And he used to always talk about the Rutgers conspiracy, which was really the idea that we end up, meaning, students of color, lawyers of color, that we want to end up everywhere. But the premise of that Rutgers conspiracy is that you have to be educated in an environment where every voice counts, where it's very inclusive, and where you're actually talking about issues of justice. And that means when you go off in your different directions, or you go off in your different, you end up on a board, you end up, as a prosecutor, you end up in the public defender's office. What happens is then the conversations about justice with classmates that reflect the diversity and inclusiveness of this country and of the community resonate in your head, right? So you're actually taking value with you for being educated in a way that is almost, is a step towards anti-racism because it is truly inclusive. And you take those voices and fight the battles where you are. And that means that, and you get this conversation a lot with respect to the criminal justice system as to how can you be a prosecutor, right? How can you go be a prosecutor? But I think what we've seen across the country in Philadelphia is that there's this sort of progressive prosecutors movement where instead of looking at the metrics in terms of how many people do you throw in jail, how many times do you get to go in court, I got the bad guy, and whatever, narrow, racist, I would say, normative assumptions guided prosecutorial offices, you start saying, no, my role here is to do justice. And I'm going to do justice in as many ways I could do justice in this office with the power that I have. By the same token, someone who's sitting on the board of directors at a corporation has an opportunity, and the boards we know tend to be almost predominantly white, predominantly male. But for me to have someone out of our conspiracy there, going with the faith that they've had these conversations, that justice is not just some imaginary concept to them, that they've engaged in concepts about justice with people from, the broad cross-section of the country, to me, provides, additional faith that they're going to be able to, at some point, draw the line when it needs to be draw the line. One of the things that you can't teach, that's the essence of law, and you read it over and over again, it's the essence of social justice advocacy, is courage, right? It's courage. And that means if you're going to be the only Latino or the only woman on a board and they're moving off in some crazy ass direction, you're not going to go along to get along. I want my students to come out with courage to say, whoa, wait a second, let's think about doing this, even if it means that you're unpopular at that moment. So, I think the questions you raise are definitely important. They're extremely difficult because, you go through the whole issue of at what point are you legitimizing the system, and at what point do you need to sort of step back and withdraw, from any potential of legitimizing, an inherently unjust system.
We do
Excellent.
have another question in the chat.
Yeah, so I'm gonna get to that question in a second. I just want to let our speakers know that we're going to do this last question, and then I'm going to come back to all of you. And my question to you is going to be, what resources would you direct people to if they want to be more deeply engaged in issues of racial justice? So everybody be thinking about that question. And then the question that was in the chat, which was a question, well, I'm going to go to Zachary's question, was a question about why is it that we require, high-priced lawyers to do a lot of things that could actually be done by somebody who doesn't have a JD. And so as we talk about barriers to the profession, if we opened up the ability to do some pieces of the practice of law by folks who are, paralegals or who have some sort of, higher training, wouldn't that also open up these opportunities to a wider swath of people of color, people who are first gen, all those other folks? Adnan, do you have any thoughts about that? Our lovely elitist profession?
Yeah, I mean, I'm pretty sort of open on these ideas. I think that, as I noted before, I think, in order to truly be an anti-racist profession, I think in general, we have to think about the ways in which we can sort of think about the margins more and not just the centers of power. And so if there are ways in which we can open up the space of lawyering or areas that were traditionally just for lawyers without sort of whatever harm is thought to potentially come from those areas being done by non-lawyers to society as a whole. I mean, I think we should be thinking about these things, and we should be thinking about ways in which to open that up if that is going to empower more people in our society. And that should be I like these type of ideas which help us to push the envelope and to basically complicate all these assumptions upon which we tend to exist.
Excellent. Do you want to throw out resources?
You're coming back to me for the resources?
I'm coming back to you. That's right.
Oh, wow. All right. So I was going to do something a little more unconventional, which was I think that in order to truly do racial justice work, you have to think outside of the law completely as well. And that your reading needs to, and one of the things that we do in law school is you're just reading a lot of law stuff. So for me, I was going to tell you, and Norrinda had brought up Ibram Kundi's book. I think Stamped from Beginning is actually the one which I would refer you to as opposed to the Antiracist book, which is also good. I would tell people, read Frantz Fanon, Wretched of the Earth. I think that this was a book that was read by many people in the civil rights movement elsewhere. It takes a more global perspective as well. And I think that that's one of the things that we have to also do is think more globally and not just in very American-centric ways about these issues. So I was going to encourage that. I was going to tell them to read Toni Morrison, read James Baldwin, that I think that in order to truly sort of understand the context in which the law operates, you need to read these philosophers and these intellectuals.
Excellent. Elise, do you want to offer up some resources?
I like that last one. I like Adnan's idea. I think it's very important to step outside the law. I guess you're saying I can't just second.
You can absolutely just second that if you want to.
I think that's terrific. I think we have to open our minds and absolutely to look beyond the four corners of the law, because the law in and of itself can be very oppressive, and we know that racism is deeply embedded in many aspects of the law. So I think to imagine a different world, a different possibility, we'd have to reach beyond our discipline. So I think interdisciplinary work, interdisciplinary teaching, don't just rely on cases and to our fellow professionals in teaching, but actually draw on, social science and the like, history, of course. And I'm just going to leave it there.
Great. Norrinda?
I too second what Adnan said. I want to offer a few other titles here. I'd mentioned How Capitalism Underdeveloped Black America by Manning Marable. I read that over quarantine, and it really gave me some life. Also, Afrofuturist work on social justice. Adrienne Marie Brown has a collection called Octavia's Brood, and it encourages all to ideate in group over what liberation in law school, in this sense, an anti-racist law school might look like, that we first need to see it. And so I encourage us to think about that work, but also to think about revisiting art that we've thought about previously, but maybe can, listen to with a different lens. I've been listening to Marley and Kuti, and just taking them in a different way. Obviously, Angela Davis's work and Ruth Wilson's work on abolition and liberation are helpful in us ideating about where we think anti-racist curriculum could help in liberation work in the law. So I look forward to seeing everybody else's ideas.
Thank you. Katie?
Yeah, so these are fantastic ideas, and I would definitely echo all of them, and I wrote some of them down to go read myself. I'm going to come back to Adnan's point he made at the very outset of this, which is the importance of legal history. I think one of the things that's been really profoundly transformational for me, and that I see influencing the folks who I talk to about these issues, is recognizing just how much our past in some ways looks like our present. And I think that gives us a window into recognizing racism in our own time, to see the places it's evolved from and the ways it is still the same story that we were hearing in the 60s or in the 30s, et cetera. The other thing I'll say is read critical race theory, right? This has been in the news right now, but there is lots of wonderful information to, lots of like really amazing work going on out there, lots of amazing work that's been going on for decades. I have a thread up on Twitter, which I'll put in the comments here. I encourage everybody to put our ideas in the comments so that people have them, about just some of the most recent work I've been reading. There's lots of really amazing, interesting work going on out there, and I encourage you all to read it.
Thank you. Adil?
Yeah, so many good suggestions. So look, I know you folks have a lot of reading right now. So yes, if you haven't read it already, put The New Jim Crow on your list. But I know you've got a lot of reading right now. So here are two things. So one, Lawrence Fishburne is about to do an audio version of the autobiography of Malcolm X. Definitely check that out. Let your eyes rest and just absorb the words. But the other thing that I wanted to suggest, Paul Butler, who is a professor at Georgetown and kind of a legend in American criminal law, he posted a 9 or 10 minute, basically what his opening argument in the trial of the police officers who killed Breonna Taylor would look like. It's very short. It's less than 10 minutes. It's incredibly powerful and effective. And I actually want to suggest it basically as one view of what anti-racist lawyering might look like. I know many folks on this call are probably pulled by ideas of prison abolition and other forms of kind of critical thought about criminal law in general. Totally. But this is one way to be an anti-racist lawyer. And the thing that I want to emphasize is not just the humanity and the empathy and the personal power of his argument, but the fact that it is all structured around an extremely sophisticated understanding of legal doctrine. So the narrative that he presents and the story he tells and the argument he makes all hangs on just a rock solid and deeply nuanced understanding of legal doctrine. And I do want to remind folks that one of the things, and this is picking up on something Professor Boddie said earlier, we are trying to help you folks become anti-racist lawyers. And so the legal doctrine that we teach, it can sometimes feel a little disconnected from the things we're watching on the news, but it isn't, right? At the end of the day, all of it is for a purpose, so that you add value to what the organizers and the protesters and the movement leaders are doing, so that as an anti-racist lawyer, you are adding something really unique. And hopefully that part of your legal education will enable you to do that. So I just wanted to mark that up.
Okay, super quick, David.
I think all of these are great suggestions. I think it's really important to get back to some of the first sources, Du Bois and Douglas, and to really understand that many of the issues that we're dealing with are recurring, entrenched issues. When you read James Baldwin, that could have been written yesterday. I circulated something to our faculty today from the ABLS students in 1969 about anti-racist curriculum, although they didn't use that term. So, and that grew out of a police killing in Newark in 1967. So I think it's really important to go back and read some of the historical sources and really recognize that we're dealing with issues that are very deeply entrenched and are just taking a different variation in terms of, where we are culturally today. But I think, these are really deep-seated issues. I think it's important to build upon that always to move forward.
And I'm going to finish us up also steering away from books so your eyes can rest a little bit. So I'm going to give you a couple of podcasts. The 1619 podcast, which is a companion to the 1619 Project from New York Times. Intersectionality Matters, which is Kimberly Crenshaw's podcast. And then Here to Slay, Hear, to Slay. That's the only one you have to pay for because that's on Luminary. But that's Roxanne Gay and Tressie McMillan Cotton, who are both fantastic Black feminist scholars and great to listen to. So I just want to thank everybody for participating in this conversation today. Certainly want to thank all of our speakers who took time to do this today, many of whom are teaching or have already taught today or will continue to teach today, and Professor Zulfiqar, who's actually on sabbatical and joined us today. So I appreciate that. And thanks to all of you for being here to listen to this conversation. I hope that it was illuminating and also hope that it is, helps us continue to move forward in ways that we all value and that are important for our country. So thanks, everybody, and hope you'll jump on for some of the sessions this afternoon.
Many thanks to Dean Mutcherson for putting this together.
Thank you.